All right, well, welcome everyone. My name is Ron Smith. We're in New Hampshire here, and we did this on a irregular basis for a few years, talking about the Constitution, talking about civics in general. And we started this whole thing, of course, because of the ignorance and the lack of knowledge about the Constitution and about civics generally. All right, I'll just go through the basics, and if that bores you, stay with us because we'll get into some more detailed stuff later on. What is the Constitution? Constitution is a law. It's the highest law of the country, of the United States. Constitution Day, this September 17th, is the day that the Constitution Convention published or sent out the Constitution that they had drafted to the states in 1787. And the Constitution itself is structured very much like the way that Great Britain was, the way England had their system set up. You know, you can almost directly compare a lot of the aspects of the Constitution to. Yeah, similar, except they have a king. We have a president who is selected by the states periodically and is accountable to the people. Their parliament, though, the House of Lords, is kind of similar to our Senate. Their House of Commons, which is closer to the people, is similar to our House of Representatives. The way they had their system there, but it's a little bit different. We have a federated system. We have the states and the federal government, so it's quite different, or somewhat different in that respect. And the way that it got started was, of course, colonies got pissed off with King George, declared independence. He had 13 colonies, and they said, okay, we are 13 countries on our own. We're independent, and we're all allied together to fight Great Britain. And that was the Declaration of Independence in 1776. Then after they did that, they said, oh, all right, we got to do something now. We got to form a government. We got to do, So they came up with something called the Articles of Confederation. So actually, the Constitution we have now is Constitution 2.0. Constitution 1.0 was the Articles of Confederation. That was in shortly after they declared independence. And that was something that they just threw together very quickly to have an alliance so that they could fight the British, and so that they could trade among themselves and have some sort of an organization. And it didn't work out too well. It was basically a treaty. It was a treaty between these 13 different countries. And taxation was voluntary. If they wanted to make changes to the Articles of Confederation, they needed unanimous. Everybody had to, all the states had to agree, all the countries had to agree. So it wasn't too workable. And after the war ended, during a war, people come together. That's just human nature. But after the war, after the Treaty of Paris, then they started fighting among themselves. We had the war veterans were upset because they weren't getting paid because the Articles of Confederation couldn't compel taxation to help pay for them, and there were just a whole bunch of problems. So they organized the Constitutional Convention, and that met, it started in May 25th, I think, of 1787 was when they began the convention. And they sat in a hot summer room arguing about all these different things for a few months, and they came out with the Constitution. And they sent it out to the states again on September 17th, 1787, and they sent it out. And of course, there were all kinds of issues in the Constitution, which we can get into later on. But right after they sent it out, and they asked the states to ratify it. And there were several issues at the time. First of all, the Articles of Confederation, when they went to this Constitution, it was supposed to be, okay, we got to have this Constitution to try to figure out how to fix the Articles of Confederation. And of course, to make any changes to the Articles of Confederation, they needed unanimous, all 13 countries, all 13 states, to ratify it. But instead, they said, okay, we're going to do this new Constitution 2.0, and it's only going to require 9 states to ratify it. So that was an issue right away, but it still worked. And then, so they sent it out to the states, and right away the states said, hey, where's the Bill of Rights? There's no Bill of Rights in this Constitution, because the Constitution they drafted at the convention didn't have the first 10 amendments, which are the Bill of Rights. And so that was something that a lot of states were not going to ratify the Constitution unless it had a Bill of Rights. And so they said, okay, all right, let's make a deal. If you ratify the Constitution, we promise, cross our hearts, that we'll do a Bill of Rights. And they did it, and the states ratified it. I mean, that's the way they hit the culture at that time was such that when somebody gave their word, it meant something. And so when they said, okay, the Congress, the future Congress, we will do a Bill of Rights and tack it onto the Constitution if you ratify it, then the state said, great, we're in, and some of them, enough of them. And then on about a year after they sent it out to the states in 1788, in, I think it was June 21st, I think it was, of 1788, New Hampshire, actually, this is where we are in New Hampshire, put it over the top. We got the 9 states, and they said, great, we've got a Constitution, we're ready to roll. And then the next year, the Congress met in 1789. And one of the first things that they did, they set up the courts, they did a whole bunch of stuff. They were not a do-nothing Congress. They were a do-something Congress. They got the country started. So they drafted the Bill of Rights, and there were they had these 12 amendments to the Constitution that they proposed to the states, and we're familiar with 10 of them. Most people are familiar with 10 of them. And they ratified those 12. But there was a process involved there. Madison was, kind of like the father of the Constitution, and so he felt like he had a say so in what the Bill of Rights were going to be. And he actually, when they drafted the original Constitution, he was opposed to the Bill of Rights. He said it's not necessary because Congress only has the powers that are granted to it in the Constitution. And so anything else they can't do. So we don't need a Bill of Rights. And he was wrong, of course. We definitely needed those Bill of Rights. But after, when they decided to put the Bill of Rights in there, and Congress got to work on that, Madison, he had a big long list. There was a couple dozen, I think. I can't remember how many, 20, I don't know how many he had proposed. And they reworked them and came up with 12 and sent those out to the states. And that was wasn't known as the Bill of Rights at that point, I don't think. But they sent those 12 out to the states. And then the states ratified 10 of them. There were 2 that the states did not ratify. One of them had to do with the number of representatives. They wanted to have a number of representatives that was proportional to the population, so that as the population grew, the number of representatives would grow. As the Constitution was really drafted, it was completely up to the Congress how many representatives they were going to have. Actually, the original Constitution set the number of representatives that each state would have starting out. But after this first census, then Congress could set that amount of representatives for the whole country to any amount they wanted, with a upper limit of no more than 1 representative per 30,000 people. That one failed. And then the other one was a amendment that would restrict, or it would require that if Congress raised their own pay, that pay raise would not go into effect until after the next election. So if the people didn't like that they raised their pay, they could vote them out of office. That was the idea anyway. That one failed also. And so the First Amendment of the Bill of Rights, as we know it, was actually the Third Amendment of the ones that were proposed. So when people say, "Oh, the First Amendment," that's the reason they made it first was because it's so important. Well, no, it was the Third Amendment in the original ones that they sent out, but it became the first one because the first two didn't pass. And so they sent the Bill of Rights out in '89, and or was it? Yeah, they drafted it in '89, right, the first year of Congress, and they sent that out, and that eventually got ratified in '91, December 15th, '91. So that's how we got the first, the Constitution and the Bill of Rights started. The first 10 amendments, yeah, right, were done all at once, and in total now we have 27 amendments, and let me see if I can go through them just from memory. I got them here, but I'll see if I can go through them from memory because that'll be more fun. Okay, First Amendment, everybody's familiar with that one. Congress shall make no law respecting the establishment of a religion. In other words, the government cannot say, this is the state religion. We're a secular government. And they can make no law prohibiting any exercise. So people are free to exercise whatever religion they want. And Congress, and it's very interesting because they say Congress shall make no law. It was a restriction on Congress, the federal government. It was not a restriction on the states. The states could still make laws that restricted things at that time. So First Amendment, religion, no establishment of religion, free exercise of religion, freedom of speech, freedom of press, freedom of assembly, and freedom to petition. That was the First Amendment. Second Amendment, everybody's familiar with that. They said, we got to we need a militia to help defend ourselves, so people can carry guns. Basically is what it was. People have the right to bear arms. Third Amendment was, these are all but the Bill of Rights again. These are the ones that were done at the very beginning. Third Amendment is no troops cannot come into your home and take over your house and live in your house, because I guess that was a problem they had. The British were doing that, and so they put that in there. Although they can do it in a time of war, but only in a manner that Congress specifies by law. I don't know if Congress has ever done that or not. Probably not. And then the Fourth Amendment is, of course, the prohibition against unreasonable searches or seizures. It doesn't prohibit searches and seizures. It doesn't even require a warrant, but it does require that they be reasonable, and that if they do, well, actually, it does require. It does specify that. I mean, you can do it without a warrant under exigent circumstances, but not. Anyway. Also, when they issue a warrant, it has to be sworn by someone that the facts in the warrant are true, and it has to specify exactly what they're looking for and exactly where they're going to look for it. The Fourth Amendment requires that there be probable cause. In other words, that a crime has been committed. In other words, the police cannot search something of yours, your home or your papers or effects. Effects means movable property that you carry with you. They cannot search those things unless it is more likely than not that you have committed a crime. That's basically what it means. And the Fifth Amendment, okay, I'm doing this from memory, so Fifth Amendment has a few things in it. It has to do with procedures and trials, I think. It has to do with the Fifth Amendment also has a provision that requires that for really serious crimes that they use a grand jury for the indictment. And it also has the Double Jeopardy Clause, the clause that says that a person cannot be charged twice for the same offense. not testifying against yourself, a provision where the government cannot deny you life, liberty, or property without due process. That means they can't can't come and take your property unless there's some legal process that they go through to do that. That's fair and just. They can't kill you, and they can't take away your liberties. They can't throw you in jail unless there's some due process to that. And that whole due process thing is actually pretty interesting. It comes into play again in the 14th Amendment too. 6th and 7th Amendment have to do with jury trials in civil and criminal cases. The 6th Amendment, the one that deals with criminal trials, requires that the accused get a speedy trial, that the trial takes place in the same district that the crime occurred, so they can't accuse somebody of a crime and drag them all the way across the country. It allows a process by which the accused can compel witnesses to come testify in their behalf. It allows the accused to confront the witnesses that are against them, and it gives the accused the right to an attorney. You know, the Miranda rights that they read. If you have the right to remain silent. If you can't afford an attorney, you can get an attorney. All that stuff. That's all the 5th and 6th Amendment. And in the case of a civil case, it's if the civil case is greater than $20, then you can get a jury trial. 8th Amendment is the prohibition against cruel and unusual punishment. Also, the 8th Amendment says no excessive fines and no excessive bail. 9th Amendment is a nice one. that's says that any right that is not enumerated, in other words, if we didn't write it down in the Constitution, then it belongs to the people. Basically, I should probably read that one just so we can. All right, enough from memory here. I'll actually read that because that's kind of important. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Now, the retained by the people kind of comes into the next amendment, the 10th Amendment. It says the power is not delegated to the United States by the Constitution, nor prohibited to it by the states, are reserved to the states respectively or to the people. So now what does that mean? Is it the states or the people? They said or. And the way it works out is the states basically have plenary power. Anything that is not granted to the federal government, the Constitution, that power belongs to the state. And the rights that are not enumerated, according to the original Constitution, the rights that are not enumerated in the Constitution, then the states can either continue to allow people have, or they can restrict those rights with laws. And so that when they say the rights retained by the people, that's what they're talking about. If the people are, strong enough to hang on to their rights in the state, then they keep them, and they can't be violated by Congress or the states. So it's kind of complicated, but basically, just because it's not written down in the Constitution as a right doesn't mean that you don't have it, and that comes up all the time. And then the 11th Amendment. So that was one of the first 10 amendments, Bill of Rights. Then the 11th Amendment, they found kind of a little loophole in the thing where somebody in one state can sue a person in another state, and it can kind of supersede what the federal government does. And anyway, that kind of took care of that, so that it has to do with doing suits between the states. And in the 12th Amendment, this came after the election of 1800. Election of 1800 was very contentious. Anyway, it ended up being a tie. The Electoral College ended up being a tie. It had to go to the House of Representatives, which is how that works. We have an electoral system where the states, electors from the states vote, and that's very controversial nowadays too. Everybody wants a popular vote, I guess, these days. But anyway, the electoral system, they vote, and if if there's a tie, or no, if nobody gets a majority, 50% plus one of those electoral votes, then it goes to the House of Representatives to vote. And the way they had it originally was whoever got the most votes was president, whoever got the second most votes was vice president. And that was, if you had two major contenders who were against each other, then you'd have one guy as the president and the next guy as the vice president, and that's who is his enemy. So that's not a very stable situation. So anyway, they wrote an amendment to fix that, and so now there's a separate ballot, electoral college ballot, for the president and the vice president. That basically is what happened there. Then there was nothing. Nothing happened for a long time. The Constitution was stagnant for many years, 60 years, and in the beginning it was pretty good. Once they sorted out this business with between the Federalists and the Democratic Republicans and Jefferson, we had Jeffersonian democracy basically after that point. For many years, and things went pretty good for white men anyway for that period. Wasn't too good for everybody else, but it went pretty good. But then in the original Constitution, they had the issue of slavery, which they knew they weren't going to be able to resolve. It was too contentious at that time, but they needed to get the Constitution going. So that's what Susan Rice calls a birth defect of the Constitution, is that. Yeah, that's Condoleezza Rice, not Susan Rice. Condoleezza Rice said that America was born with the birth defect of slavery. Is that it had slavery written right into it, which is very bad. But that became an issue then, and of course we. Led to the Civil War, and because we went 60 years without an amendment to the Constitution, and the Constitution has to be amended, has to be updated to the times, all the time, constantly, and so that was a big problem. It's like stopping up a pressure cooker or something. If you stop up the pressure cooker and you don't let it vent now and then, it's going to explode, and that's what happened. It exploded into a Civil War. So we fought the Civil War. Fortunately, the North won, and we got the what's called the Reconstruction Amendments after the Civil War. The way it started, right? The South broke away; they wanted to get out of the Union. Lincoln said, "No, you can't do that," and we fought a war and freed the slaves. And after the Civil War ended, in order to get those states back into the Union, we went through this process, this they call Reconstruction. And there were 3 amendments: the 13th Amendment, the 14th Amendment, and the 15th Amendment. The 13th Amendment was to free the slaves. The 14th Amendment was kind of complicated. There's a lot in that one. Yeah, we can get into the details of that later, maybe if I get into it. But it basically said that in the 14th Amendment, the first clause of the 14th Amendment is birthright citizenship. Anybody born in the United States or naturalized in the United States is a citizen of the United States and a citizen of the state that they live in. And that corrected that horrible Dred Scott decision that the Supreme Court made. Other parts of the 14th Amendment deal with prohibiting the states from restricting the rights of people. You remember I said at the beginning that rights remain retained by the people, that the states had plenary power to restrict any rights that they wanted to. Well, that was a problem, right? Because they were enslaving people. That's about as bad as you can get in terms of taking away people's rights. So after the Civil War, we said, no, you can't do that in your states. You can't make laws that just take away people's freedoms and enslave people and do horrible things. So they wrote this. One of the main things in here was that no state shall deprive any person of life, liberty, or property without due process of law. So originally, that due process clause was only for Congress. After the Civil War, the 14th Amendment, that and a bunch of other things applied to the states as well. So one of the questions was what things did apply to the states and what things were still part of only federal. And there were a whole bunch of Supreme Court cases that dealt with that, and it was a process called Incorporation, meaning that we need to decide what when they say life, liberty, and property, what does that mean? What does liberty mean? What does it, They didn't even agree that it was all of the enumerated rights in the Bill of Rights. So they had to go through this process of incorporation, and there was this big issue. Should we, the Supreme Court said, should we do it just all at one time in bulk and say, okay, everything applies to the states too, or not? And of course, they did it the hard way. They said, no, we'll do it one by one. And so there have been a whole bunch of these cases. It makes it very complicated to figure out, but basically one by one, all of the rights, I think they've got them all now, have been incorporated to apply to the states now. So the states cannot violate those rights. And there were some other things in the 14th Amendment. Yeah, everybody has the right to vote, of course. Everybody who's white and male, and at that time black too. Then the slaves were freed, who was 21, but not women at that point yet. Yeah, the right to vote. Anyway, there's a whole bunch of insurrection, right? All the states that were basically insurrectionists against the Union. They couldn't hold office. That was one of the things, unless Congress, let them. Congress would have to pass a law that said, okay, we're going to forgive you, and then you can be an officer again. Also, that Insurrection Clause in the 14th Amendment only applies to people who have been officers in government, either an officer in a federal government or an officer in a state government or a judicial official, something like that. It doesn't apply to an ordinary citizen who has never been a politician, but somebody like a representative who was in part of the insurrection, and if they get charged and get convicted of insurrection, they wouldn't be able to hold office anymore. So, and that has actually come up today. Remember, that was something I promised, I guess, was that this program here would talk about how this affects it today. The January 6th insurrection. If those people get convicted of insurrection, then they cannot hold office anymore. They can't run for president. They can't hold any public office. Unless Congress pardons them. So that's something that applies today that was written way back in after the Civil War. Anyway, there's a whole bunch of things, handling debts, things like that. 14th Amendment is very complicated and a big deal. And the 15th Amendment gave the right to vote to black people, or the former slaves. And Congress, the 16th Amendment then was the next one. That took a long time again. It went several decades before the 16th Amendment, which happened during the Progressive era. Has to do with taxation. The original Constitution, when it talked about taxes, it said that taxes had to be allocated according to the per capita. In other words, if two states both have 1 million people population, then the taxes collected from those two states have to be equal. Or if one had 2 million and one had 1 million, then they have to be proportional to the number of people, and which meant that you couldn't do just a straight income tax, because incomes are different. They vary. So, we'd gone through the Industrial Revolution, and there was a lot of a disparity in wealth. There were a lot of wealthy people and poor people, and so one of the things that they thought they could do was to institute a income tax. And so that's what the 16th Amendment was. And that gave us the IRS. So that kind of sucks. I'm not. I'm going to try to avoid commentary, but we did at that time. All right. 17th Amendment then came around the same time, same year actually. That was originally the selection of senators. There are two houses of Congress. So originally the senators were Congress just left it up to the states to select their two senators from each state, and the states could do it any way they wanted to. The legislature could do it. They could tell the governor to pick them any way they wanted to. They could pick their senators, and over time, most of the states had already gone to a popular election to select the senators, but this 17th Amendment said that the states had to do it that way. They had to pick their senators through a popular election, and that's how we do it today. So, and in the 18th Amendment, I think it was just a distraction. They were doing all these progressive things, and I think they needed a distraction. They didn't want. That's in my opinion, I guess. Anyway, the 18th Amendment, everybody knows that's prohibition. They said we're not going to have the temperance movement. Got that passed, and it didn't actually prohibit the consumption of alcohol, but it prohibited transportation, manufacture, sale, and transportation of alcohol, which made it very difficult. But it didn't prohibit actually the consumption of alcohol. 19th Amendment was to give women the right to vote, and actually it's even more broad than that. It didn't specify that now women have the right to vote. It said that any gender could vote, which at the time there was only a concept of two genders, but the way they wrote it, they said right to vote shall not be denied or abridged by the United States or by any state on account of sex. So it's more broad than they even thought of when they wrote it, more broad than what people even think of today. It's not just women can vote, but it gives everyone the right to vote. Transgender, any gender. So I don't think they had the foresight there. It's just the way they happened to word it. And the 20th Amendment. 20th Amendment is kind of interesting because that's the first amendment to deal with. I think was the first amendment to deal with the advancement of technology. I mean, this is 1933. By then, we had radio, we had telegraph, we had, the airplane had been invented. I mean, it was, people were able to move a lot more quickly. And under the original Constitution, they had this long delay between the election for the president and the Congress and the time that they got sworn in. There was this huge, several months because it took time. The only way they could communicate was by horseback, and it was very difficult. So that they had this big long delay in there, and he didn't need that anymore. And it was just a big problem because he ended up with lame duck. If the incumbent lost, then it was more difficult for him to govern because everybody knew he was going to be out in a few months anyway. So that was a problem. Long lame duck section was not good for governance. So they changed that, and so now it happens much more quickly. It happens in January 20th. January 6th is when they count the electoral votes, and January 20th is when the president gets inaugurated. It used to be in March. On the 21st Amendment, we screwed up on the 18th Amendment. Let's fix that. Get rid of that one. That was getting rid of prohibition. And the 22nd Amendment, this one came after FDR. During, I think people are familiar with FDR. He was during the Depression. In 1929, you had the stock market crash, and then the Depression in the 30s, and it was pretty dire straits for everybody. And FDR was very popular, to say the least. very popular guy. We had just come up with the radio, which he exploited adeptly with fireside chats. You've heard of those, the fireside chats. So he had a lot of power, and he had a lot of. He was very popular. And up until he became president, all presidents would only stay in the office for two terms, up to 8 years. And so in Washington set that precedent, by the way. He did 2 terms, and he said, "No, I'm not a king. We got to elect a new president all the time." And so all the presidents went by that, all the way up until FDR. And FDR said, "Nah, I think I want to be president for life," and he did. He was president until he died. So after that happened, I mean, he did a lot of good things. He got us out of some tough things. He was very controversial. He did shift a lot of power to the government, which is a lot of people don't like that. I guess it depends upon your political philosophy. It did help out the situation in some cases, but it did have a legacy that caused more problems later on. Anyway, after he died, everybody said, "Hey, we just had a king. Basically, we just had somebody who was president for life. We don't want that to happen again." So they passed the 22nd Amendment, which is term limits for the president. The president can only run for re-election, or run for election twice. He can only run for re-election. And it's actually, in theory, a president can be president still for 10 years under this amendment if the way it's worded, if like, for example, if Biden resigned today, then Harris would become president, and she would finish out Biden's term, and she could run for re-election and run another 4 years after that. So she'd have, a little over 6 years. But if Biden waited until after January 20th of 23, next year, and he resigned, then Harris could finish out his term, run for re-election for another 4 years, and then run for re-election again for another 4 years. She could have almost 10 years in office. So anyway, that's how it works. The way it's worded, they can run for re-election twice, and if they serve more than half of a term, then that's counted as a term for in terms of term limits. 23rd Amendment was the poll tax, I think. Yeah. 23rd Amendment was poll tax, and 24th Amendment was allowing the District of Columbia, D.C., to participate in the Electoral College. Yeah, those two are reversed. The 23rd Amendment is the amendment that gave D.C. Participation in the Electoral College. They got 3 electoral votes, which is the amount that they would get if they were a state. And the 24th Amendment got rid of the poll tax. When those two happened during the 60s, which is when the Civil Rights Act the Civil Rights Movement was really heated up. End of the 50s and early 60s, and throughout the 60s, the Civil Rights Movement was really going full steam, and so those were 2 amendments that helped address that. One of the techniques that Jim Crow laws use. Jim Crow laws, for those who don't know, were laws that after Reconstruction, after the Civil War and Reconstruction, the South were still racist. They didn't like black people, and they didn't want black people to vote. So they passed all these laws that were technically legal, but still prohibited black people from voting. And one of those techniques was to have a poll tax, to require people to pay a tax in order to vote. And often they would put in what they call a grandfather clause in that. In other words, anybody whose father or grandfather had voted before didn't have to pay the tax. So black people couldn't vote before the 15th Amendment. So they had to pay the tax, but white people didn't. So that was just one of the Jim Crow laws that was oppressing black people. So the 23rd Amendment took care of that, got rid of the poll tax, and the 24th Amendment gave people who lived in Washington, D.C. The right to participate in the Electoral College. And then 25th Amendment, that came after, Kennedy was assassinated, right, or during in the early 60s, and that it made people think. There were a couple assassinations, but when the president got assassinated, there was it made people started thinking about secession and how to handle that. And before that time, it was just basically, we had a president and a vice president. What if both of them got shot? Then what do we do? It really wasn't very clear. Yeah, actually, presidential succession was provided for in the original Constitution. It said that the vice president would take over if something happened to the president, and then Congress it gave Congress the power to enact by law who would would be in line of succession after the vice president. And they did that. They created the Presidential Succession Act, and that's been updated periodically over the years. So they did the 25th Amendment, which is all about secession and how that works, and how to if somebody if a president is incapacitated somehow, anyway, that's all covered there. And Congress, it gave Congress, some of it is spelled out in the amendment itself, and some of it is left up to Congress. And basically, the way secession works now is it's by the order of, it's the first in line is the vice president, second in line is the Speaker of the House, third in line is the president, the leader of the Senate, and then after that, then it's the cabinet members, the cabinet secretaries, and it's I think the first one is Secretary of State, and I forget. It goes in the order that the offices were established, and so I think it's Secretary of State, and I forget Secretary. I forget. That's hard to get from memory, but anyway, that's how it works. And then the 26th Amendment. 26th Amendment was the last new amendment to the Constitution. 1971. So if anybody asks you when the Constitution was written, you can tell them it was written in 1971, because that's when we finished writing the Constitution. The last words of the Constitution were written. Actually, before that, let me look. I'll look up the exact date so you guys can tell folks if somebody ever asks you when the Constitution was written, you can tell them the real date that it was completed, or at least so March of 71 is when when Congress sent it to the states, and that of course was during in the late 60s and early 70s. We had got involved in the Vietnam War, and up until that point, the voting age was 21, which is what the 14th Amendment had said. 21 people who were 21 years or older had the right to vote. But during the Vietnam War, it was not a popular war, and in order to get soldiers, they had to have conscription, a conscription army. In other words, the draft. They had to draft people and force them to go to Vietnam to fight. And of course, people didn't like that, and it was done in a way that was not very fair. People who had political connections or who had a lot of money were able to get out of that. If they had, just for example, bone spurs in their foot, they could get out of it. people didn't like it. It was unfair. So that was one of the reasons why we actually had a war at home as well as a war in Vietnam during that time. I mean, there were bombings every week in the United States from people who were protesting the war and protesting the government. It was very confrontational, to say the least. Anyway, so one of the arguments of the people who were getting drafted, these kids who were 18 years old, who were getting drafted and sent over to Vietnam, was, hey, we don't even have the right to vote. It's kind of like going all the way back to the beginning when we say, taxation without representation. It's like saying, hey, we're drafting without representation. We don't have the right to vote. So how can you send us to go fight? And so that's where the 26th Amendment came from. And that of course gives the right to vote to anyone who's 18 years of age or older. And so that was the last new amendment that was written in 1971, and it was quickly ratified by the states. So that's the last new amendment. But we have 27 amendments. So how did the 27th Amendment come? And this is the most interesting story to me, anyway. I find it very interesting. The 27th Amendment. Remember at the very beginning, I told you that the Bill of Rights were actually 12. There were 12 amendments that were proposed in the Bill of Rights, but only 10 of them got. Well, one of those was this amendment that I said that required that when the Congress raises their pay, that it doesn't go into effect until the next election. That got shot down back in the 18th century when the first Constitution was the Bill of Rights was first drafted. But there was a guy named Gregory Watson who took a college course, and he was studying the Constitution, and he said, and he was originally doing something else, and in his research he found this amendment that did not get ratified. And he said, and he thought to himself, he said, well, there's no time limit to getting an amendment ratified. So technically that amendment could get ratified now. And so he changed what he was doing on his paper, and he wrote his paper on the 27th Amendment and said, this amendment could get ratified today. And he turned it into his teacher, and his teacher said, no, you're full of crap. I'm giving you a C. He got a C in the class. And he didn't like that. So he said, I'm going to prove to them that this can be ratified now. And he did it. He wrote letters to all of the legislatures that had not ratified that amendment yet, of the states that had not ratified that. And they did it. They ratified the amendment. Enough of them ratified the amendment. And then in 1992, that amendment that had been proposed back in 1789 got ratified by the states in 1972. So it took over 200 years from the time that Congress had proposed that amendment until it got ratified. And it was entirely this one guy who did it, this Gregory Watson. So he actually went back and they revised his grade, gave him an A+ in the class after that. So that's an interesting little story. The preamble of the Constitution. This is kind of interesting. Everybody's familiar with that. We the people, and then it goes on. I'll read it very quickly. We the people of the United States, in order to form a perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. That's the preamble of the Constitution. Now, one thing that everybody always gets confused about is it says, we the people of the United States, in order to form a more perfect union. And so the word today, when people hear the word perfect, they say perfect means flawless, right? You can't get any better than that. So how on earth can they say form a more perfect union? If it's already perfect, how can it be more perfect? And almost everybody gets this wrong. They think that it means flawless, and that by forming a more perfect union, that the Constitution, when it gets amended and we improve things and stuff like that, we're making the country more perfect, better. So, but that's not what it means. If you look at the dictionaries at the time, they had that definition that we use today mostly, but the primary definition at that time was like complete or like certain. That's what perfect meant at that time. And remember, when they were drafting the Constitution, the people who were drafting the Constitution, what they were thinking was, hey, we've got this 1.0 Constitution that wasn't working out. It didn't make the union tight enough between the states in order for it to function. So what we want to do is make a more perfect, in other words, like complete union, or more like certain union. And union meaning, coming together. This treaty that they had, which now is going to be more than a treaty once they got that ratified. So that's what perfect union means. It doesn't mean that we're trying to make things better. It means that it made the union more complete, basically. So yeah, if you read the preamble of the Constitution, that kind of sums everything up in terms of what they wanted to do. Establish justice. Of course, that's not just courts and cops and stuff. That's not what justice means there. That means establish a fair, just system of laws, and ensure domestic tranquility. That was a big issue because, as I said, after the War of Independence was over and they were still running under the Articles of Confederation, there was a lot of domestic protests and fights and people trying to be, rebellions and things like that going on. So that was a big deal, and then provide for the common defense, of course, promote the general welfare. There's kind of an interesting thing about the wording on that. They say provide for the common defense, then they say promote the general welfare, meaning that when I read it, I see provide for the common defense is something that they definitely were going to do, and promote means that they were going to do things to try to promote people to help help trade, make trade easier, things like that. And the word welfare, in modern times, people think of welfare as the government giving people subsidies, giving money or food or whatever as welfare, but that's not what that meant there. And secure the blessings of liberty to ourselves. And of course, they wanted to have this thing work for many generations. So anyway, that's the preamble to the Constitution. So now you learn something about what perfect is. A lot of what's going on today has to do with the Supreme Court and how the Supreme Court cases and the way the Supreme Court decides cases gets people all upset. And I think the main reason is because instead of Congress writing legislation to address all the issues and the things that have changed in our society and writing new amendments to the Constitution, they're just leaving it up to the courts to do it, and that's a problem because the court is not, person's not elected. It's about as far from the people as you can get in our system, other than maybe regulators or something. So that's a problem. And there've been different cases. The abortion case that they had just decided, Dobbs, one of the reasons why everybody is upset with that is, of course, when Roe v. Wade was decided back in the 70s, that was a controversial decision. And then they reaffirmed it, a couple times and said, yeah, we're going to continue. They modified it a little bit with Casey. But then now here just recently, Dobbs' decision comes down and they reverse that. And there's a thing in case law, especially with the Supreme Court, that you've probably heard of, called stare decisis, which means that once a decision is made, you should try to keep that decision made. Don't change it again. And the reason why they have that principle, it's not in the Constitution, it's not anything that's in law, it's just something that the court does. They try to maintain, follow the decisions that they have made in the past. But in this case, they didn't do that. They reversed it after a long time. So that was, and the reason why they have that principle in the first place is because otherwise the court could change back and forth depending upon who they liked in the case or whatever. That wouldn't be rule of law anymore. That would be rule of man. That would be people just arbitrarily deciding. Somebody could come with a case one day and they rule one way, and then the next day somebody comes with the same case and they rule another way and just ignore the previous decision. So that's why they have stare decisis, so that it's for credibility of the court, it's for justice, it's for fairness. And so that's why they have that. So, and the longer that a law is on the longer that a decision has been followed and upheld, the more drastic it is for the court to come around and change that. So that's why a lot of people were upset about that, in addition to the actual issue itself. But in terms of the constitutionality and the way the courts work and stuff. So that's why people were so upset about that one, in part anyway, is because they had a decision that was made a long time ago. It was upheld by subsequent decisions. There hasn't been any changes in society or in technology or anything like that that would really affect that decision in a way that would cause them to reverse it. It was just, they said, we want to reverse it now, and they did it. So that's kind of a problem. And one of the things that they did, the way our system works, of course, we have the three branches of government. You got the executive, the president, you have the Congress, and then you have the courts. And when the Supreme, the way it works is, when the Supreme Court takes a case, they look at usually just the law. They try to figure out what the law says, and based on the facts, the record of the case, they apply the law and try to figure out what the outcome of that case will be. And if there's any ambiguity in the law, then they try to figure out what the law says. That's their purpose. Sometimes they work with statutes, and sometimes they work with the Constitution itself. And sometimes they will do something that Congress will pass a law, maybe restricting somebody's fundamental right, and then the courts will look at that in a case and say, no, Congress, you can't do that. The Constitution says you cannot do that, and they will invalidate the law that Congress had made. It's called overturning legislation from the Congress. It's kind of interesting that is not part of the Constitution either. Interestingly, it's like stare decisis. It's not written in the Constitution. There's nothing in the Constitution that says Supreme Court is the place where we decide what the law says, and the Supreme Court can overturn legislation from Congress. It doesn't say that anywhere in the Constitution. So in the original Constitution, it does say, Article 3, Section 2, that the Supreme Court does, in fact, have jurisdiction over interpreting the law, kind of, if in cases other than when it has original jurisdiction. In other words, when it's hearing appellate cases on appeal. It says the Supreme Court shall have appellate jurisdiction both as to law and fact, with such exceptions and under such regulations as Congress shall make. So Congress can regulate that pretty much any way they want. But as far as the Supreme Court having, the Constitution saying anything about the Supreme Court being able to overturn laws of Congress, nah, that's not in there at all. The way that happened was way back in the early in the 1800s. There was a case called Marbury versus Madison, and this was the first case where Congress, or where the Supreme Court did that, where they overturned a case that, or a law that Congress had made. It's kind of complicated. I don't know if you want to get into the weeds or not. I know I did some beginning stuff, so let's do some more advanced stuff. Marbury versus Madison. Remember I told you about the election of 1800s? Very contentious election. Very, you look at elections we have today, that one was really contentious. And it was between Adams and Jefferson. Adams was trying to run for re-election, and after this big long battle, and after this 30-something ballots in the House of Representatives, Jefferson finally prevailed. And but then Adams was in office till March, remember, because they had that long lame duck period. And so what Adams did is he went around and first he had Congress on his side, so he passed a bunch of laws to try to entrench their power, and he also went around and appointed a bunch of judges in different positions, and created, in this whole process, created a bunch of new judge positions all over the place in the government, and placed his loyalist people in all those positions. And his Secretary of State, the process of doing that required that the Secretary of State, who was John Marshall at that time under Adams, commission all these judges, and they had fill out official paperwork and deliver these commissions to them, and that would make it official. And he was hurriedly trying to do this, and Marshall wasn't able to get them all done. He actually had his brother do it, which is kind of nepotism. So there's a lot of stuff going on back then. It was very similar today. So anyway, John Marshall had his brother go around and try to deliver all these commissions, and they ran out of time. And he wasn't able to. There was this one particular judge, Marbury. Marbury was going to be a justice of peace somewhere or something. There's some bizarre thing, and his commission didn't get delivered to him by the secretary, by Marshall, so he didn't become judge. And Jefferson took over, and Jefferson said, "Forget it. I'm not gonna deliver your commission. You're just a loyalist for Adams." And he told his Secretary of State, Madison, not to deliver the commission to Marbury. So Marbury was all upset. He wanted to be judge. He wanted to get his cushy salary or whatever his thing was. So he filed a suit with the Supreme Court to try to get something called a writ of mandamus from the Supreme Court to force Madison to deliver his commission. It's called a writ of mandamus. I think it's when the Supreme Court does stuff, they do them with writs. That's how they do their orders. And a writ of mandamus means by hand. It comes from the Latin by hand. It means we will make you do this thing. So Marbury wanted the Supreme Court to issue a writ of mandamus to Madison to require him to deliver his commission and make him a judge. And Jefferson didn't want to do that. None wanted to do it. And interestingly, through this whole process, Adams, one of the Supreme Court justices retired or died or something during that time, and Adams made John Marshall, who was his Secretary of State, who was supposed to deliver these commissions, he made him the Chief Justice of the Supreme Court. So the guy who was involved in the case, who was supposed to deliver all these commissions, is now sitting on the Supreme Court as the Chief Justice of the Supreme Court. And then Marbury brings this case to the Supreme Court, where John Marshall is going to decide the case. I mean, you talk about conflict of interest. Anyway, so that's so the Supreme Court had this case, and they had to decide. There were a whole bunch of things they had to decide. They had to decide whether, first, whether they were they were the right place to decide the issue. They were supposed to decide, and one of the things they had to decide in this case was whether or not the Supreme Court. They had to decide whether the law that Congress had previously enacted about federal judges, if that law still was in effect. One of the things that law did was it changed the jurisdiction of the Supreme Court, so that it said that in the Constitution, the only time that the Supreme Court has original jurisdiction means that you can bring the case directly to the Supreme Court instead of having to work your way through the inferior courts. So one of the things that this law that they had passed about the federal judiciary was that people could bring cases directly to the Supreme Court, in addition to the ones that are enumerated in the Constitution. And so they had to decide. The Supreme Court had to decide whether or not Congress had the power to make that change through legislation or not, as part of the thing that they were doing with that case. And so, what Marshall did, of course, he knew that Jefferson was the enemy in this case, and he was totally. He should have recused himself, obviously, but he didn't. And so what he ruled was, he ruled in favor of Jefferson, but in the process of ruling in favor of Jefferson's side, in other words, he dismissed the case. He didn't give Marbury his commission, or what Marbury wanted. But in that process, he said that the reason why we're not going to give Marbury his writ of mandamus is because the law that Congress had passed about the federal judiciary is unconstitutional, because it expanded the jurisdiction, which allowed people to bring cases directly to the Supreme Court, giving the Supreme Court original jurisdiction over things that the Constitution never said that they could. So in doing that, he was saying, yes, the Supreme Court has the power to overturn legislation that Congress has passed, and that's what they did. They overturned it. They said this Federal Judiciary Act is not constitutional in this one particular respect, so we're invalidating that congressional legislation. And by doing that, it meant that Marbury was not allowed to bring the case directly to the Supreme Court under original jurisdiction, and so they dismissed the case. So Marbury lost his case. Jefferson won that battle, but the Supreme Court, under Marshall, was able to make a huge power grab in that, and they got the right to, or the power to have court review over constitutionality of acts passed by Congress, legislation passed by Congress. So that's how that got started. That whole, I know it's a long-winded story. How much time? We still got some time. So that's how the Congress got this power to interpret the Constitution and to invalidate laws that Congress had passed. And I mean, it's a tradition that goes all the way back to England and everything, but it was the first time that it had been applied under this, Constitution with the Supreme Court and everything. So it was a big deal, and it was a lot of power for the Supreme Court. And that's how they got that power to begin with. In other words, Congress, the Constitution didn't give them the power. Congress didn't give them the power. The president gave them the power. They took the power. They decided they had that power. And because at the time, Jefferson won his battle, he saved face and everything. He went along with it, and it just became the tradition, and that's how it's been done all along. I mean, technically, the court with this most recent Dobbs case, they reversed something that had a decision that had been made a long time. Technically, the Supreme Court could go all the way back to Madison and Marbury versus Madison and say, no, that was a power grab. The Supreme Court wasn't allowed to do that, and reverse that decision. That would kind of throw things that wouldn't work. But anyway, technically they could do that. Second Amendment, that always gets everybody fired up. There have been some recent cases on the Second Amendment. Well, there's an interesting case that happened in the 90s, actually, that has to do with the Second Amendment and this thing called the Commerce Clause of the Constitution. Way back in the 30s, during the Depression, when FDR had all his power, he got the court to expand the meaning of the Commerce Clause, which in the Constitution it says that Congress can make laws regulating interstate commerce, regulating commerce between the states, and they have expanded that thing that basically lets Congress do almost anything based on that presumption that they can regulate interstate commerce. So if somebody, the particular case that began the whole thing was Wickard v. Fieldman, where a guy was growing on his farm, he was growing crops and feeding them to his animals. And Congress said, no, we can regulate that. Even though he's not growing the feed to sell it interstate, and even though he's not selling his animals interstate, by growing those crops and feeding it to his animals, he could have bought those crops from somebody in another state. So it affects interstate commerce just a little bit, but that's enough for them to be able to regulate it. So that decision has just basically opened the door, and for years and years and years and years, all the way up into the 90s, every single case that has come up about interstate commerce, the Supreme Court has upheld Congress's power, until we came to this United States v. Lopez in 1995. There was a law that the Congress had enacted called the Gun-Free School Zone Act, Gun-Free School Zones Act, which prohibited prohibited carrying of guns within 1,000 feet of the school or something like that. This guy Lopez was I think he was a student at a school or something. He wanted to carry a gun around school anyway. And so he sued about that law, and it went to the Supreme Court. And so what the rationale was that Congress, because of the interstate commerce power, they said they could prevent somebody from carrying a gun near a school. And now I don't understand how those two things relate, but they figured, well, maybe he bought the gun interstate, or maybe, who knows? Maybe he bought gasoline in another state in his car or something. I don't know how. Somehow they said that they could do that. And when it got to the Supreme Court said, nah, this is, it's a fundamental right, and it's something that actually they didn't go to that point. They didn't go to fundamental right. They used another rationale for overturning it. They overturned it, and it finally put a limit to what Congress could do under the Interstate Commerce Clause. But then later on, in this century, then we had, or just recently actually, we had some cases on guns. DC versus Heller was the first time that the Supreme Court. Imagine that. If the Constitution is over 200 years old, and finally the Supreme Court is looked at the issue of what the Second Amendment actually means. Does it mean just why is that the right? Why do people have the right to carry a gun? And they said, at the minimum, it includes the right to possess a gun in the home. DC was trying to regulate preventing people from even having guns in their own homes, and the court said, no, you can't do that. The Second Amendment gives people the right to do that. So that was the first part of it. Then there was the incorporation step, which, remember I was telling you about it, incorporation. I didn't get into that too deeply, but the 14th Amendment, I talked about that. The 14th Amendment applied the fundamental rights guaranteed in the Constitution to the states, so that states cannot violate those rights also. So once they established with Heller that this was a right that cities can't take away, then or that Congress can't take away, then McDonald came by and actually officially said, okay, we're incorporating this, so none of the states can interfere with that right. And then later on, there was the Bruin decisions, New York State Rifle and Pistol Association versus Bruin, where the right to carry the gun can't be infringed. New York had a rule where they required a license, and in order to get the license, somebody had to come up with some exceptional reason why they needed to carry a gun, other than hey, it's the Second Amendment. They had to come up with some rationale, and it was virtually impossible for anybody to get a license. Only people who were politically connected or bribed the officials or whatever got their license. So the Supreme Court said, no, you can't do that anymore, and so now all the states must issue, unless somebody is a convicted felon or something like that. If they apply for a license in a state where a license is required, then they must issue the license. So those are Second Amendment cases. Oh, I know what we can talk about. Roe v. Wade, that original decision back in the 70s, that was it was a real controversial decision, and it was really kind of flaky with the way they did it. A lot of people, even people who agreed with the idea that abortion should be legal, still criticized that decision because of the way they went around about it. They used the right to personal privacy. The right to personal privacy includes the abortion decision. There's a quote from the decision, and that always confused me, because today, when you say the word privacy, it means without any context. If you just say privacy, that means having information that you control and you limit to yourself or to people who are close to you, and you don't allow it to be public, or you don't allow it to go to someone who you don't want to have that information. That's privacy. And it could be just your password or personal communication, anything like that. That's what privacy means today. But the word itself, privacy, comes from Old Latin, which means to separate. And way back when, like in Rome and early republics, it meant to separate what is the purview of the government and what is the purview of the people. You want to get those separated. or sorted out. So that's where the word privacy came from. So when the Supreme Court was using that word privacy, and they were trying to, I understand why they were doing it. They were trying to avoid using the word liberty in the context of abortion. So they used the word privacy instead, basically. And it just meant that this is something that is private rather than public. It has to do with, it's like saying something that is government sector versus private sector. That's where that's the use of the term in that case. So that always confused me. Why they used privacy. I mean, there are a lot of things that, criminals, when they do their crimes, a lot they try to keep their activities private. So that didn't make sense to me that they would try to do that. But it's a different meaning to the word privacy, and they're just trying to avoid using the word liberty in that particular case. So that's what that meant, was they were saying that there are certain things that are the purview of the individual private person, and in things that have to do with the government, public. But to find that, the Constitution doesn't spell that out anywhere. There's no right to privacy in the Constitution. So they said, well, the 14th Amendment and the Fourth Amendment, the First Amendment. He ended up using the term was the penumbra. The penumbra of the Constitution has this right, and so people jumped on that. Anyway, so it's a very controversial decision, and the current court has reversed that now with Dobbs, and now it's the way that works is, now that the courts has said, no, this is not a right guaranteed by the Constitution, now Congress has to act. Congress can pass a law today, if they want, to legalize abortion to whatever number of months that they want, if they want to. But they're claiming that well, no, they can't. They're saying, oh, we can't do it because of this 2/3 thing in the Senate, the filibuster rule. Actually, to end a filibuster is not 2/3; it's 3/5. To end a filibuster, they need 3/5 of all the senators that are holding office, and normally there are 100 senators, so that would be 60 votes to end a filibuster. The 2/3 is to override a veto, and that's 2/3 of the senators present. And also to ratify treaties requires 2/3 of the Senate. However, the filibuster rule is a rule of the Senate. It's not written in the Constitution at all. And each house of Congress can make up their own rules, and the Senate can make up their own rules. And that filibuster is a rule of the Senate. And rules of the Senate can be changed with a simple majority of the Senate. So with a majority, the Senate can get rid of the filibuster in order to pass something with a simple majority of the Senate, if they want to do that. But the way that this decision the reason why this decision happened was because Congress overrode the filibuster rule to get a majority vote in order to approved judges to get onto the Supreme Court, and then those judges reversed the Roe decision to make abortion illegal again. But now the congressmen are saying, no, we don't want to override the filibuster to make a law to address what the Supreme Court just did, it just doesn't make any sense to me. And this presentation is about the Constitution, not about politics, but there's definitely some politics going on there. What else can we talk about? Yeah, First Amendment decisions. Yeah, there's been a whole bunch of First Amendment decisions. It's very interesting. At the very beginning of the country, that was one of the big deals, was First Amendment freedom of speech. Everybody having freedom and liberty, and that was the whole reason for starting the country. But first thing they did when Adams got in there was he got Congress to pass a this Aliens and Seditions Act, which severely limited the freedom of speech. And the Supreme Court upheld part of that for a long time, but eventually they overrode that. And then remember I said the First Amendment, there all the amendments, the rights in the Constitution only, or at least the First Amendment, one that specified that Congress can't do something, only applied to Congress at that time. And then when the 14th Amendment happened, the 14th Amendment said that some unspecified liberties cannot be violated by the states. And then there were subsequent Supreme Court cases that incorporated that the prohibition so that states could not violate the First Amendment rights of free speech and free press. There have been several different ones. Some big ones here. There was one that actually happened. This was kind of interesting. What else? Rex v. Zinger was one that happened in 1735. Before we even, it was in the colony of New York, where a judge upheld freedom of press. So that was even before the country got started. But there's a big one, New York Times versus Sullivan. That was a big one. And what that protected was that it allowed publishers or anybody to say things about public officials that, in other words, if you say something about a public official, you have much more latitude in terms of what you can say. You can say something that might be defamatory if you said it about an ordinary person. And the reason that is because one of the main reasons of having First Amendment protection is so that we can discuss public issues and candidates and things like that, so we can make the democracy function. And so the Supreme Court said, yeah, we got to allow much more latitude in speech and press when it concerns public officials. So that was a big one. Well, here's Hustler versus Falwell. That one you probably won't hear about because it has to do with a pornographer. There's a guy who published a pornographic magazine called Hustler, and it was versus a guy named Jerry Falwell, who was a preacher, TV evangelist or whatever. And Hustler published this really obscene cartoon about Jerry Falwell saying things about his mother and everything. It was pretty gross. So Jerry Falwell sued Hustler, but Hustler won that case because even though the statements that Hustler was making were false about Jerry Falwell's mother, it was obvious from the context and everything that it was not true. Nobody would believe it. They knew it was satire. So he couldn't sue them saying, they were making false statements about me, because it was obvious it was satire, and everybody knew the thing was not true. So that was another interesting First Amendment case. There's another thing I learned every time I've done these things. I've learned something new about the Constitution, about history and all that. And there was remember I was talking about the amendments that have been proposed and not ratified. Well, one of those is called the Corwin Amendment, which was made during the antebellum, before the Civil War. There was an amendment proposed that would entrench in the Constitution slavery. It was already there was already some stuff in there about slavery, and they were talking about amending the Constitution to get rid of slavery, of course, before that time. And one of the proposals was this Corwin Amendment, and it passed Congress, but it was never ratified by the states, that said that slavery would be legal forever, and there would be no way to amend the Constitution to get rid of slavery. That's what the Corwin Amendment said. And I found out just a couple days ago that Lincoln was in favor of the Corwin Amendment, which doesn't even make sense, right? Lincoln's this guy who freed the slaves. But he was in favor of that amendment before the Civil War as a way to prevent the Civil War from happening, which is just mind-blowing that was the case. And of course, after this, they rejected the Corwin Amendment. The states didn't get enough to ratify it, and that led, and then they went to the Civil War, and then ironically, the amendments that came that would have been the 13th Amendment to the Constitution, but instead the 13th Amendment freed the slaves, and we got and the 14th, 15th Amendment which is the opposite of what the Corwin Amendment was trying to get to. So that was an interesting thing I learned. So I guess we're out of time now. So thank you all for joining, and I think this will be available.
Drop the mic.
On YouTube.
Drop the mic.
For viewing later.
Drop the mic.
And I appreciate everybody for watching.